Jeremy Wright.
Thank you very much indeed, Madam Deputy Speaker. In view of the number of people who wish to speak in this debate, I'll restrict my remarks to the amendments in my name and the name of others. Those are 47, 48 and 49. And these amendments are focused on the stage in the process which involves the multidisciplinary panels established in clause 14. And the purpose of these amendments is to make that system work better. A panel is intended to be an additional safeguard. The Honourable Lady for Spen Valley has made that very clear, and they are, of course, the successor to the involvement of a High Court judge assessing the merits of each case. And the role of the panel is to determine whether it is satisfied of the matters set out in clause 15, subparagraph 2. Now, some of those matters are procedural. For example, whether or not the person seeking the certificate is aged over 18 or resident in the UK, or that declarations and assessments that should be made have been made. But others are matters of judgment, including professional judgment, such as whether an illness is terminal or whether the person applying for a certificate of eligibility has the mental capacity to do so. But the remaining category of matters to be considered are matters of broader judgment. And those are likely to be, I suspect, where the panel focuses most of its attention, particularly the last two on the list in clause 15. And those are, first of all, whether the person applying has a clear, settled and informed wish to end their life, and secondly, that there is no coercion or pressure from anyone else. And on those matters, the panel will hear from the relevant doctors who will have had to make a judgment on those things, but I do not think the intent of the bill is or should be that the panel simply confirms the doctor has reached a judgment and then adopts that judgment. The panel should, of course, reach its own judgment. It's right, of course, too, that the panel will also hear from the person wishing to die and will make its assessment of them. But particularly on the last matter, the absence of coercion or pressure, it may well be that highly relevant evidence will come from others, from family, friends or others who know the person well. And we are familiar with at least one scenario where a new partner has isolated the person in question before they suddenly and unexpectedly change their view on their own assisted death. The problem, Madam Deputy Speaker, is that under the bill as it stands, it's very difficult and perhaps impossible for those who know the person seeking a certificate well to know that those proceedings are underway or in prospect. They may not know, and nobody has to tell them, that the person has made the relevant declarations, or even that they have an intention to die, or indeed that there is any reason to submit any evidence they may have. Now, Madam Deputy Speaker, I am not saying that every case where someone has not told their family and friends of their decision to seek an assisted death will be concerning. But I think it is fair to say that a disproportionate number of the concerning cases will be in that category. And in those cases, the panel may be making a judgment in the absence of relevant, perhaps crucial evidence, and they simply cannot do their job properly if that is so. Amendment, of course I give way.
Is my friend concerned, as I am, that the panel doesn't even need to consider looking at evidence from family or friends or those caring for or treating the person? And is my right honourable friend also concerned that while they may be required to hear from the person, that is only unless there are exceptional circumstances and there is no requirement to actually ask any questions at all?
Yes, I understand the Honourable Lady's point, and I've seen her amendments on this subject, which I think are very sensible. And I think we need to think about the way in which the panel process will actually unfold. And if we believe, and that I think is a common view, that this is an important safeguard, we need to do everything we can to make sure it's an effective one too. And just as her amendments seek to do, my Amendment 47 seeks to remedy this problem by ensuring that the Assisted Dying Commissioner notifies anyone they think may have relevant evidence to give so that they can give it. That evidence may, of course, not change the panel's decision, but in some of the most troubling cases, it will. And the opportunity for the panel to consider that evidence when the stakes are this high must surely be provided for. Now, Madam Deputy Speaker, I accept that what I'm proposing is an infringement on the privacy of the person wishing to die. It is a fetter on their ability to choose to die without informing their family or friends, as they may wish. But this bill is all about balancing the rights of a person to die as they wish with, on the other hand, our duty to protect the vulnerable from abuse. That is exactly why the stages through which a person must go in order to be assisted to die are in this bill, including obtaining the grant of a certificate from a panel, which, as I say, to be of value, must surely add new protections to the other stages.
I want you mind running on that point.
Very briefly.
Very briefly.
Hayes.
In its original incarnation, we were assured that one of the key safeguards was a legal test. Had that been retained in the bill, of course, that process would have enabled the collection of evidence in the very way he's describing. It is partly because the safeguard's been weakened, we have the dilemma that his amendments seek to deal with.
Well, I understand my right honourable friend's point. I'm not sure I entirely agree with him. I think some of the procedural problems I'm describing would have existed even with the previous iteration of the bill, but certainly with its current iteration they are there, and what I'm seeking to do at this report stage is trying to fix the problem. And it's really a problem because it arises from the difficulty of the three qualified individuals that will constitute these panels to express a considered judgment. And if we are to have added value in the panel stage of this process, we have to enable the panel surely to make good judgments. And good judgments come from the capacity to assess all the relevant evidence. The bill as it stands makes it very hard for the panel to have access to all that evidence in every case, but perhaps especially in those cases where its additional safeguard is most needed.
On that point,
I give what?
Let's just to raise the point in regards to the panel and the concerns that again were raised by the Royal College of Psychiatrists, and actually their point 5 in their concerns is actually it's not clear what the psychiatrist's role on that panel would actually be.
You're right.
Well, I think the Honourable Gentleman makes a fair point. I think what we can expect is that the psychiatrist on the panel will subject particularly the requirement on mental capacity to some considerable professional scrutiny. But nobody on a panel, whatever their professional competence may be, is capable of doing the job properly if they haven't access to the necessary evidence. And that's the point that I'm making. We must make sure that they do. Now, I would also argue that the fact that the panel may sit in public is not a sufficient answer to the problem I'm raising. And that's first because there will be many panels considering many cases. And we cannot expect those who have evidence of coercion, for example, to watch the lists in case the person they know may happen to appear in them, when of course they have no expectation that they will. And secondly, because the panel will not sit in public in every case. Schedule 2, paragraph 6 says, and I quote, panels are to determine referrals in public. So that is the clear presumption, and that is welcome. But paragraph 6.2 says that the chair of the panel may decide the panel will sit in private at the request of the person to whom a referral relates. There's nothing I can see in the bill about any grounds on which the panel chair may refuse such a request. So it will certainly occasionally, or perhaps often, be the case that the panel will sit in private and no one will know what it is doing. Madam Deputy Speaker, the next issue is the way in which a panel will go about making the judgments it needs to make. And that brings me to Amendment 48. Now, most judicial and quasi-judicial hearings, as we all know in this country, are conducted on an adversarial basis. And that is not, by the way, a reference to the tone of proceedings, but to the presentation of both sides of an argument, so the tribunal can reach the right conclusion. That is what our judges and lawyers are used to. And that matters here because, again, this quasi-judicial stage in the process of seeking assistance to die is being offered as important reassurance that things are going to be done safely. But it cannot offer that reassurance if panels are being asked to adopt a process for which they are ill-equipped. And that is not a criticism of those who will sit on those panels. And I accept that under the bill as it stands, a panel may hear from and may question any other person beyond the person seeking the certificate and the relevant doctors. But as I've sought to address in Amendment 47, as things stand, those other persons will in all likelihood not know about the panel's proceedings and therefore will not come forward with the evidence of their own initiative. The panel would have to go out and find them. And how exactly are they to do that? How do the panel know who may have relevant evidence to give, and with what resources will they seek them out? The position on what resources will be available more generally for the process under the bill remains unclear, but the impact assessment suggests that panels are expected to deal with 2 cases a day, and that suggests they'll spend somewhere between 3 and 4 hours on each. That, Madam Deputy Speaker, is not much latitude for further investigation. So Amendment 48 proposes that the Commissioner should notify a designated authority on an application for a certificate. The Secretary of State can choose the appropriate one, and that authority will supply an advocate to the panel with the responsibility to raise arguments against the grant of a certificate which the panel will not otherwise hear. And I think that is important because it ensures that there is another participant in the panel process who can at least help the panel by prompting consideration of concerns, reservations or grounds for further inquiry before decisions are made. And finally, Madam Deputy Speaker, my third amendment, Amendment 49, is about what happens once a panel has reached its conclusion. Now, Clause 16 provides for a person seeking a certificate to be able to ask for reconsideration of a panel's refusal to grant one. But of course, the bill currently provides no equivalent right to someone who believes a panel should not have granted a certificate to challenge that decision. Anyone in that position would need to resort to judicial review, which is complex and expensive.
Could I gently suggest to the Right Honourable Member that he might be bringing his remarks to a close? There are many other members who wish to contribute this afternoon.
I certainly am, Madam Deputy Speaker, and I'm doing my best, I hope as briefly as I can, to explain what are technical amendments in a hugely important bill, in a part of the bill that the promoter has advocated for because she believes it's a safeguard. I think it's important, Madam Deputy Speaker, that we establish whether it is such a safeguard and if it can be improved, how it can be improved, but I entirely take your strictures on board and I will come as quickly as I can to a conclusion. And Madam Deputy Speaker, the reason I'm making the point I'm making is that this is not an equality of arms point. I accept that these are not opposing parties in the traditional sense, but it's really about the presentation of new evidence. Presumably, advice to someone whose application for a certificate has been refused and who has new evidence to present would be to reapply to the Commissioner. But what is someone who has new evidence to challenge the basis for an existing certificate to do? Judicial review is no help. That's about the soundness of the decision already taken, which will be assessed using the evidence already presented to the panel which took the original decision. And the obvious scenario here is where someone comes forward after the granting of a certificate, perhaps because they did not know of the previous proceedings, with pertinent evidence of coercion. There is currently no mechanism for that evidence to be considered. And I'm not suggesting that people should simply be able to delay the process without grounds. My amendment suggests that the Commissioner will need to screen all such applications to ensure there's an arguable case to be made. But, Madam Deputy Speaker, finally, I make these amendments and put them forward because I believe it's important at report stage in this bill to accept that the bill may become law and to make it the best law we can make it. This particular phase of the process can only be a safeguard if we enable the panel to do its job properly. These provisions are currently defective in that respect, and I think it's extraordinarily important that we make them effective for the panel to do its job properly.